I have Mario Hernandez.
Ready, Jeff?
Come on up. 2240195 is called Mario Hernandez. That's you?
Yes, sir.
Present. With Mr. Kelly, your attorney in the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
We do, Your Honor.
In summary, this indictment alleges that on or about March 10th, 2021 in Jefferson County, Texas, you committed the second-degree felony of indecency with a child. Do you understand what you're charged with here?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached where you would be pleading guilty, prosecuted for the lesser included offense of okay. What is the offense?
Indecent assault. Class A.
What's the section number, please?
20.
I got 22, I guess. Indecent assault 22.012. A person commits an offense without the other person's consent with intent to arouse or gratify the sexual desire of any person. Person touches the breast of another person. This is a class A misdemeanor. All right. The have agreed to that you would be pleading guilty to lesser included class A misdemeanor indecent assault,
He gets disgusted,
which is
as he should.
found under section 22.012 of the Texas Penal Code, which carries with it up to 1 year in the county jail and or up to a $4,000 fine. Do you understand the punishment range?
Yes, sir.
The agreement is that you would be placed on deferred or unadjudicated probation for 2 years. Is that your understanding of the agreement?
Yes, sir.
Also fine $500.
Yes, sir.
If I follow that, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this class A misdemeanor, lesser included offense under this indictment? Indecent assault, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document?
Yes, sir.
Understand it? Discuss it with your attorney? Or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
Objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
Is that true?
Yes.
State's Exhibit 1 is made a part of the record for all purposes. Printing's getting smaller. These don't have it. This doesn't have a reporting requirement, does it?
Only on the second offense, Judge.
Thanks for your patience. Just
Thank
okay. I think I understand all of this here.
This is another one of those instances where he took a lot of time to review all of the elements of the case. And I cut out all of the dead space so that you guys didn't have to sit through and wait while he read. But he really wanted to make sure he had a handle on exactly what happened with this case, what the plea is, what the terms and conditions are going to be of the plea, to know if he's going to follow this recommendation and how he's going to proceed. because as you'll find out, he's not a happy man.
How old was the child? 10 years old?
Yes, sir.
10. Predator.
So the only difference between this and the second degree felony of indecency with a child is the fact that y'all just dropped the age of the victim, right? As an element.
Yes, sir.
Everything else is the same.
Yes, sir.
Okay. All right. Anything else?
Not from us, Judge.
Okay. It looks like sex offender registration is not required yet.
It's not mandatory. No, sir.
That bothers him.
And it didn't get passed in this term, I guess.
No, sir. Not to my knowledge.
Because the statute says it's sexual offender registration is not required, and then it's in parentheses yet. So apparently, for whatever reason, they elected not to. The legislature elected not to change that other code. Well, anything else?
Not from us, Judge.
All right, and the defendant has entered his plea of guilty to this Class A misdemeanor. Is a pre-sentence report waived?
Yes.
Anything else to add? If not, I'm going to find Mr. Hernandez, you have pleaded guilty to this Class A misdemeanor, the lesser included offense of what is referred to as indecent assault. And under section 22.012 of the Texas Penal Code. You have pleaded guilty voluntarily. You are mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. However, I am going to follow this agreement, defer any finding of guilt, and place you on deferred or unadjudicated probation for 2 years. You will find $500. There will be terms and conditions of probation, which are normal and customary for this type, a general type of offense, even though I wanted to go to sex offender classes and other things like that, that are normal and customary for other types of the offenses.
This one bothers everyone. If you're not bothered
especially
by
in
it,
light of the fact that
something
the
wrong.
complainant was 10 years old at the time of this event. There will be other terms and conditions of probation which are normal and customary for this.
He's so bothered
Now,
he can't even get through it.
You're also going to do
He's
180
struggling.
days in the county jail. This is a crime of indecency. A 10-year-old child is victimized. You're going to pay a price for irreparable harm to a child on my watch. I just wish it was more. You took advantage of a 10-year-old more than once, according to the probable cause affidavit. And except for everybody just dropping the age, it's a second-degree felony. Plus mandatory reporting requirements for life, I believe.
He should be.
Otherwise. So
He shouldn't get this deal.
what this court can do in managing the fair and appropriate remedy that I guess we can assess, although how do you take back the harm to a child? There is no way. You took advantage of a child. I have no sympathy for you. I have sympathy for the child. You took advantage of a 10-year-old child. Shame on you. You're going to jail immediately. 180
Thank you,
days
Judge.
as a condition of this probation.
Your Honor.
Anything else?
Yes, Judge, if I may, considering that he's employed currently, will the court allow us to break that up? In
I know
some
you're
way,
doing your job, but shut up.
I don't have something to proffer to the court right now, but I would at least like to ask the court to.
Let me just say-
to consider.
Mr. Kelly is one of the most wonderful people I know. And he's a wonderful attorney, as well as just being a very fine, great man. He has children. And I know what he thinks. I know what we all think. You didn't give this child a chance to get ready for your assaultive behavior. And you did this more than once. And I have no sympathy for you. I'm not going to work on your terms in spite of the fact I would do almost anything for Mr. Kelly. This doesn't have anything to do with Mr. Kelly. He's trying his best to help you, but he cannot undo your terrible misdeed. It was an unnatural act you performed on a child. Shame on you. You're going to jail. The most I can put you is 180 days. And that's what you're getting. That's what we call justice under these circumstances. Unfortunately, we can't undo the assault that you performed on a 10-year-old child. Shame on you. Anything else? That's in all due respect. If it was any other kind of circumstances, Tom, but I feel sorry for that child. That is all.
You can't undo it.
Okay.
There's no taking it
We
back.
have my Trong
Yes,
and Trong.
yes, Judge, we need a trial set.
Mr. Trong wants your
All right. We need a palate cleanser for a moment. Let's see if I can get a kitty cat in here. The only way that he could do more, Holly, would be if he entirely rejected the plea. I don't know the rules behind that. I've seen judges reject pleas before, but I don't know if there's certain stipulations that they have to abide by if the plea has been accepted on both sides or whatever. But Judge Stevens looked at everything and he figured out what he could do for the max. And he gave him the max, as much time as he could, 180 days. So the truth is that's not much. But it's the most the judge could do under these circumstances. I know we all wish that he could have given him more. But he gave him the most that he could. And he didn't bend on, I have to work or I have to set up arrangements or anything like that. No. He said, you're going and you're going now. Yeah. All of us, sweetie. All of us. I do not have a tabby. I have a gray cat I have two that are gray and white. And yeah, he took that very hard. Absolutely. Yeah. And that is probably why they did the plea. Very often they'll try to come to a plea to save the family from having to go through the trial. I know if something like that happened to my child, I would not want my child to have to get up on the stand. Earl, I see you now. Come here. You smell this? Come on. Come on. Mama needs your lovin's. Come on. Yeah. Come on up here. The chat wants to see you and not your starfish side. Meow. Yeah. Come on. Here, let me put you right here. Oh, don't you go nowhere, Earl. Come on. Earl. He's like, I'm suspicious. Come on, baby. If it was Billy would be like, yum, let me have it. Come on, baby. He's got his starfish side at you, but you can't see it. There we go. There we go, baby. Yeah. Yeah, this is my grandbaby. This is my grandbaby. This is Earl Grey. Come on, Earl. Right here. Yeah. It's your food. He's like, I'm not really interested. I just gave them the dry food. I've got a little banister that runs along the wall, and I just take and I fill that up so that when I can't get them. Yeah, Ava will eat the cat's food. Ava will eat anything. You want Ava? Ava. Come on. Come on around. Come on up. Ava. Come here, baby. Come on. Up. Come on. The spoon is clean. All right, hold up. Tonight, she is having the classic tuna dinner. You want another? Come on. Come on up. Oh, yes, thank you. I wanted to wear that. Ava, come on up. Come on. Get that. Get that. Right here. No, not the spoon. Ava, right here. You got it on my wrist, baby. Right here. Come here. Come on, right there. No, not the spoon, silly. Ava. Oh, it fell. Now you'll have to lick it off the floor. Holly loves you. She's going for the whole can. Oh my goodness. Yeah, usually when she gets these, there's not food left in them because the cats have eaten it. Okay, you're good now, right? You're good. Here, get this little bit off my desk. Yeah. I don't need my desk smelling like tuna. Oh, Ava, I love you. I love you. Okay. See, doesn't that make us all feel a little bit better? A little bit better because we got to see baby. We got to see our baby Ava. Come on. Come on, baby. Who's the bestest girl? Who's the bestest girl? Hmm? Aw, I love you, Ava. I love you. Go lay down. Go lay down. Go get comfy. I love you, baby girl. Thank you. Mm. The inside of these ones actually isn't. I don't know what they do differently, but I've never had she's never gotten cut on one or anything, but oh, she always does. Always. Always. And she sits on my feet, which is nice in the winter, but she'll sit right on my feet and do that. So, yep. But that's one of my babies. Aww. You guys are the absolute best. Absolute. All right, now we can get back to the clip. But I wanted to have a moment of wholesome and loving, because that's what we are. She is. We love you, Mama Gemma. I'm so happy you're always here. You are an integral part of our family. Ooh. Nah. No, I haven't. Okay. It's Earl Grey and Billy O.T. So I have tea saucers, little plates. And that's what I put their food on. So they eat off of tea saucers. I know. I can't help it. Oh, no. No. No, I don't need to encourage that. I don't even eat them. I love the crunchy ones, though. Total crunchy over puff. Mm-hmm. Much love. Always. Much love. All right.
Retain on this?
I am.
Okay.
Oh, no. Oh, I see the problem.
We're gonna set this for trial, okay, and that's what Mr. Chong wants, I believe, here in
Mr. Chong.
22-412-45. And did you need to put anything on the record?
No.
Okay, all right. Then this is set for trial. It's an arson case, and we will set that for trial. Okay, thank you.
I believe we're gonna need a translator, Judge. That was correct.
Can y'all do what you can to
We
help
will.
with that? Thank you.
Thank you.
Okay, Benjamin Fullerton.
Your Honor, he wants to come to talk Friday, doesn't have 1 week.
Yes, sir. Yes, you got 1 week. There we go. And was that, you had, what did we do something with Dalen Mann?
He's on the trial docket. He refused, he's refusing deferred on that. He
Okay,
refused deferred.
Okay. Who did that?
Mr. Mann did.
Okay, that's fine.
He's reset to January 22nd.
Okay. He can always change his mind. Yeah, that's what's necessary. Robert Lofton,
Fullerton.
Robert Lofton.
Just a week.
Ready, or-
Okay. What are we gonna do on this?
Is it late?
Okay. I don't have any papers.
Mr. Ham,
Oh, it's probably, he was kind of stuck in his last hearing, I guess.
Yeah.
Here.
Or two. Hey, what's the site, Mike? There's a question about the jail time. You just did all
Eight point 302.
Fullerton, get 'em.
Okay.
Thanks, Brian.
Okay, on Robert Lofton, there we go. 23-41666 is called. Mr. Lofton is present. And with Ms. Mantellini, does the defendant waive a formal reading of this indictment? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about, it's two paragraphs, on or about December 29th, 2022 in Jefferson County, Texas, you committed the offense of theft, and I'm showing paragraph two or more, defendant has two or more theft convictions in Harris County and Jefferson County courts. And paragraphs 1 and 2 constitute the state jail felonies that we're going on. State jail felony.
Actually, no, Your Honor, it's an 8-year. Where the other paragraphs are.
No, it's a state jail felony, punished as though it was
Yeah,
as
it's a
though it was
state
a
jail
second
felony.
degree felony.
But we're.
So
yeah.
let's see. All right, I guess. I should actually.
And in deciding which
That all work?
paragraphs to go on, I believe that the paragraph alleging a December 12th, 1978 in conviction is for an act that occurred prior to the September 1978 conviction. So I believe that the court would have one out of all four of those would have one, and then the
Look,
next.
if it's a cap of 8 years, you just need third degree felony punishment, right?
Well, it has to be prior state jails to be third-degree felony punishment. I thought.
Correct, Judge.
And he doesn't have prior state jails. He has prior regular consecutive felonies, which is why it's.
No, you got,
Should,
you got
would Miss,
in paragraph.
Okay, so my niece had this dog, and it was very close in breed to what Ava is. Ava's red bone coonhound and Australian shepherd. And my niece had an Australian shepherd. I don't remember if it was purebred or mixed with something, but it was adorable. And you could put broccoli and carrots down and a steak, and the dog would have the broccoli and carrots. It loved carrots. It was like its favorite food in the entire world. Ava won't eat anything, any vegetables or fruits. Like, I can't get her to eat them. I've tried. I want her to. I've tried sweet potatoes. I've tried broccoli. I've even done the switch trick where you like offer them like, a piece of pizza or something. And right before they take it, you slip the broccoli in. It doesn't work on her. She spits it out. A lot of dogs will just eat it like as if they got the pizza. It doesn't work on her. I tried. I completely understand, Patrick. And you know what? that's what we're here for. That's what I'm here for. That's why I do this. And just think of this benefit, right? You come here to watch it, and I usually cut out all of the dead space. You don't got to sit there and listen to silence while he reads, reads up on the statute or reads up on the charge or, any of that other stuff. I cut that all out, and you have the support of the wonderful chat. So I understand wishing he had it for when he was live, but you can just do something during the daytime when the court's on and then come here at night.
You've got 2 burglaries in paragraphs 1, 2, 3, 4. In paragraphs 4 and 5 on the same date. Doesn't that make
That's
that's non-consecutive?
Therefore, they're not consecutive.
I
And
know
so,
that makes 3rd-degree felony
but
punishment.
they're not state jail felonies.
Much
They're
love, Tammy
I would
13B.
assume second-degree felonies.
That's correct.
Thank
Judge.
you.
What she's saying, I believe, is
Sleep
accurate.
well.
Any two prior state jail felonies goes to 3rd-degree punishment. Any 2 consecutive regular felonies goes to 2nd-degree punishment. Is my understanding.
What's the statute, please?
I don't have that memorized.
Well, it's penal code 12.425.
Right. Okay, let's see. Enhanced state jail. Okay. State jail felony enhanced by 2 prior felonies in sequence makes a 2nd-degree felony punishment, right?
Yes, sir.
Much love always.
And burglary and
No, sir.
well, if you have a burglary in 78, okay, and burglary of 78 and 278706, in the next to the last paragraph, it says after 278706 became final, he commits the felony of aggravated assault of a police officer and was convicted in 86. So that gets you a consecutive.
That would do it, Judge. Those 2.
I was 4 years old when he committed that felony.
So we would be using the paragraph that includes cause number 27806.
Okay,
Thank you.
so it would be paragraphs 1 and 2. And 3, and 1 and 2, which constitute the state jail felony. Then 4 and 7,
Yes, sir.
which constitute the enhancement of a burglary of a habitation and aggravated assault of a peace officer in 78 and 86 respectively, which gives you the enhanced felony punishment under section 12.42 subpart A, subpart 2, 2nd-degree felony, 2 prior felonies in sequence. Current crime, state jail felony.
We've already gotten him to sign one. If that's okay.
Oh, sure.
And felony. Enhanced with 2 prior state jail felony. 2 prior felonies in sequence 12, section 12.425 subpart B. Yeah. 12.425 subpart B. And 425 repeat for repeat and habitual felony offenders on trial for state jail felony. Okay. All right, I think that's where we are. Section 12.425, which again is a state jail, the current offense, state jail felony, paragraphs 1 and 2,
See how serious he
services.
takes everything?
then enhanced to by these prior
Ew.
convictions, 2 prior felonies in sequence becomes second degree felony, enhanced punishment range.
And I believe we're gonna go on paragraph 4 and 7
All
after
right.
what we just discussed.
So the plan is that you would be pleading guilty to paragraphs 1 and 2. And then that is a state jail felony, then you would be enhanced with the burglary of a habitation conviction in 78 and aggravated assault of a peace officer, a sequential prior convictions, conviction in 1986, and that would enhance then to, what did we say?
Second degree.
Second degree felony punishment, but it's a state jail felony punished as though it were a second degree felony. And that means that you would be facing no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
You understand?
But it's a state jail felony, but it's punished as though it were a second degree felony, and whatever sentence I assess will not exceed 8 years in prison. So you would be looking at no less than 2 nor more than 8 years confinement in prison. You could be placed on regular probation by the court for up to 10 years in length. You can be placed on deferred or unadjudicated probation. Those are 3 different options.
I'm just trying to straighten.
This is just, well, it just gets kind of awkward because there's so many issues here that we're having to fix. All right, is that your understanding of the agreement? Also, you would be paying restitution in the amount of $1,529.95.
Yes,
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
yes,
How do you plead to paragraph 1 of this indictment, which alleges that on or about December 29th, 2022 in Jefferson County, Texas, you committed this, the offense of theft, guilty or not guilty?
yes,
And paragraph 2, which goes further to state that you have 2 or more theft convictions out of county courts of law 5 of Harris County and 7 of Harris County and 3 of Jefferson County and County Court of Law 2 of Jefferson County, Texas. Paragraph, is that true and correct in paragraph 2? And are you pleading guilty to that?
yes, yes.
Thus, paragraphs 1 and 2 together constitute a state jail felony,
Ava's tootin'.
which means
I
you
heard
would
that.
generally be facing no less than 180 days up to 2 years in the state jail and a fine up to $10,000. But paragraph 4 goes on to allege in the indictment that you were convicted
Y'all heard
in
Ava.
78 in cause number 278706 out of the 177th District Court of Harris County, Texas. Is that true?
Butt wiggling
Yes,
over
sir.
here.
And are you pleading true to that voluntarily?
Billy.
Yes, sir.
And because it's true.
Here.
Thereafter, that became final. It is alleged in paragraph 7 that you committed the offense of aggravated assault of a peace officer and were convicted of that in February of 1986 in cause number 424048 out of the 232nd District Court of Harris County, Texas. Is that true?
Yes, sir.
And are you pleading true to that allegation
Yes,
voluntarily and because it is true?
yes,
Oh my God, Ava.
So
Oh,
paragraphs 1, 2, 4, and 7. You're pleading guilty and are true to those voluntarily.
guys, I gotta take this dog back outside.
Knowingly, intelligently, and because all of those allegations are true.
yes,
Thus, that constitutes a state jail felony. But because it is enhanced in punishment because of the prior convictions, you are facing no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes.
An agreement's been reached where whatever sentence shall not exceed a cap of 8 years in prison. So you were looking thus at up to 10 years of deferred or unadjudicated probation, up to 10 years of regular probation, or no less than 2 nor more than 8 years confinement in prison. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
And once again, how do you plead to paragraphs 1 and 2, guilty or not guilty, which constitute the state jail felony of theft?
Yes.
And paragraphs 4 and 7, which allege the earlier convictions in 1978 and in 1986 of burglary of a habitation and aggravated assault of a peace officer. Are those allegations true and correct? And are you pleading true and correct to those prior convictions?
Yes, sir.
I'll show you what's marked as State's Exhibit 1. Did you sign that document? Understand it? Discuss it with your attorney? Or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states that you are mentally competent to enter your guilty pleas, which are freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read them. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Is that true?
Yes, sir.
Again, you pleaded guilty to paragraph 1, which is theft, which is enhanced to a state jail felony because of 2 or more prior convictions that you have pleaded true to in paragraph 2. And that state jail felony, its punishment is enhanced as though it were a second-degree felony based upon your pleas of true to the prior convictions of burglary of a habitation in paragraph 4 of 1978 out of the Harris County District Court, and paragraph 7, aggravated assault of a peace officer in 1986 out of Harris County District Court as well. You understand all of that?
Yes, sir.
Pre-sentence report waived?
Yeah.
All right. What do you want to do?
We're asking for probation, Your Honor, and
What state say?
My initial offer was 10 years, Judge. And, I came down some in that regard. I recognize that the amount of time between his prior criminal conduct might weigh in his benefit. So what I see is just a long history of criminal conduct,
It is.
and it didn't stop in this regard. And that's why I stood with him having to plead with your honor about whether or not he would receive probation. I believe he should receive 8 years TDC.
What do you say, sir? What do you say?
I messed up
Which time?
all along up until
All right.
then and
Why, out of all of this,
I
would you
ran
come
out
back
of
and
probation.
commit a crime like this?
because I slipped. I was
What did
doing
you
good.
steal?
I didn't scan the merchandise that was on it. It was beeping, but it didn't scan. And then before he left and went out the thing, they told me, but I didn't go out there and get him. You know, I didn't rush out there to get him. And I took the stuff up to help him. And they said, hey, all that ain't been scanned. I said, yeah, I scanned it. But then the part of it hadn't went through the scan. So
there were things that you allowed to be taken that were not paid
that
for.
wasn't paid for. So they went back on the thing. They just kept me on. They said, well, we're gonna have to go back over through the video.
How long did you stay in jail when you were
I
arrested?
never went to jail. I mean, I just kept working. They said they'd go investigate.
All right.
At some point, were you arrested and are you
Oh.
on bond right now?
I stayed in jail a week. Then I came back and I went,
All right. Anything else?
I got straight and went to signed up because I'm good with computers and Google got my information and hired me and put me in class.
You need to.
So he's
But
going.
you
through
need to
some
live
classes
honestly,
with
sir.
Google.
That's what I'm doing now.
All right, well, it's never too late, but anything else? Here's what I'm gonna do. I'm gonna find that you have pleaded guilty to paragraphs 1 and 2. And 4 and 7 of this indictment, and as true as well to paragraphs 2, 4, and 7, which are prior convictions, which all boil down to this being a state jail felony conviction with a punishment as a second-degree felony because of the sequential convictions of the prior convictions in paragraphs 4 and 7. So you're looking at no less than 2, no more than 20 years confinement in prison. There is a cap in this case of 8 years, no more than 8 years confinement in prison. I'm going to follow this agreement and find you guilty of paragraphs 1, 2, and 4 and 7, which constitute, I'm saying guilty, but it's guilty really of paragraph 1, enhanced by paragraph 2 to a state jail felony, enhanced further to second-degree felony punishment from paragraphs 4 and 7 of prior convictions. And following this cap of 8 years in prison, I am now finding you guilty of the state jail felony, punished as though it were second-degree felony punishment. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years. I'm going to suspend that and place you on regular probation for 10 years. You must pay restitution in the amount of $1,529.95, sir.
In light of the fact that he's just recently has something, I don't quite understand it, but it's Google and it's an opportunity with his IT training, and I would ask the court to maybe not order any upfront time at this moment. And if he isn't, performing properly, then of course you could always.
You're gonna pay this $1,529.95, which is ordered as restitution.
I can work, I don't know how much I can get, but I will get together with people, my folk, my mom, she's still.
The quicker you pay that off, the better off it is all the way
How much a
around.
month I can pay, but I can pay some.
If you
money.
fail to follow these terms and conditions of probation, your probation can be revoked. You can be sentenced up to 8 years in prison. Do you understand? Okay, we'll get the most important thing, get this money paid back as soon as possible. Anything else?
No, Your
That
Honor.
is all. The probation officer will prepare the documents, and then I will sign that. Okay.
Thanks.
I think.
I don't believe there's a fine here on this. Did I date that
Yes.
clemency order? Thank you.
Okay, Judge,
Hold on.
sorry.
Justicia, yeah, come on and get your paperwork and move on.
Yes.
Okay, you're clear on that.
Well,
Now,
anyway, sorry, Judge.
Tom's case, where Tom, I'm here, let's go back to that. There's an issue that was brought up. Do I have anything else on this, or is that clear me?
No, you have Tyler, that was the one,
The competency.
the competency. You said
Okay.
you wanted to leave it for last.
I'm certainly gonna leave that for last.
Okay.
What you're saying, are you saying that Class A misdemeanors, I cannot order
Can't be. more than 30
confinement?
days.
in more than what?
No more than 30 days, Judge.
No more than 30 days, and what's the site on that, please? again?
42A point,
Huh?
42A
What is the name?
point 302.
Okay, confinement. 30 days in a misdemeanor case. Okay, that's pretty clear,
Yes, sir.
that, it cannot be more than 30 days. Thus, it is the condition of probation is 30 days confinement in the county jail, not 180. And such will be corrected. Anything else?
Judge, I'd like to re-urge my previous request if the court would allow me. My concern is 30 consecutive days may end up costing a job. I'm not, Judge, I'm not in any way
No, you're
ignoring
not.
what
I
the
know
court
you're
said
not. I just,
previously.
I know you're not.
I'm
And
asking on my client's behalf, and I think I have a duty to ask. And I think it's important.
I'll read it.
I appreciate
The court
it.
knows
I
too.
appreciate it. And yeah, I've considered it, but I'm not considering it long because he didn't give that little child opportunity to make a choice. And I'm not giving him any, I'm not making it I'm not making it convenient for him. I'm sorry. I'm sorry for the child. I'm sympathetic with the child. He shouldn't have done that. And this is one of those cases where it's a second degree felony, according to all the circumstances of the case. How y'all want to work that out, and that was something presented to me. And there may be some things I'm not aware of, but all things being the same, for what I believe in and what I believe the whole law was based upon, is that when you commit indecent assault on a 10-year-old child, you must pay a hefty price. That's only fair. I'm standing by that. He may lose, but I'm sure that child will never forget. That's what drives my actions, is the harm to a child, which can't be undone. Okay, that is all. Thank you.
With the excuse.
Yes.
So anyways, I wanted to get back to your comment. The lawyer in the bright blue-ish suit, he was the lawyer for the man who assaulted the 10-year-old child. What happened there was the judge made his ruling. The defendant went off to his cell to start his 180 days. And then the next case happened. When the next case ended, that lawyer decided to come back at the judge and say, Your Honor, I know you've already made your ruling, but can we please reconsider it so that he doesn't lose his job? Which was the argument that he made at the time the judge made the ruling. And the judge had already shot it down. So for him to come back literally an entire case later and to continue to advocate for his client, I understand he's just doing his job. He's kind of going overboard because his client already got the deal of a lifetime. The deal of a lifetime. That man should be sitting in a prison cell for a very long time. Not just in a prison cell, no. He should be released to Gen Pop in prison. They don't look kindly on that. Even the ones who are in there for that conviction don't look kindly on that. So the judge just shot it down another time and said, look, I'm sorry. This is what I ruled, and my ruling is going to stand, which is absolutely what he should have done. the fact that that lawyer had even come back and re-asked that, to me, that's hugely disrespectful. Again, I get he was advocating for his client. He was hoping the judge had time to simmer down, maybe. But no, you don't do that. The judge makes a ruling and that's it. You accept it. You don't argue with the judge, and that's essentially what he was doing. To me, that's just a sign of disrespect. But the judge doesn't see it that way either. The judge looks at it as he's advocating for his client. The judge has a lot of respect for that lawyer, which is probably one of the reasons why he didn't get a scolding. So, anyways, that's what happened. I hope when you said that you were confused earlier, I hope that is what you were referring to. If not, I apologize for explaining something that you understood. But that's my take on it. So, okay, good. Yeah, it shouldn't have happened. It should not have happened. So, okay. We are almost done with this docket, and then I'm sorry, we'll be done with the stream. My kitties have the zoomies right now. Oh my god, they're so cute. Hold on. Kitty break. Let's see if they continue it. Oh. Oh my gosh, I wish you could have seen when they rolled out the door. Oh, that was great. That was so great. Okay, I love our little kitty breaks.